Hello, hello, hello. It's Attorney Mike Revan coming to you from Chicago. As usual, we're on Vlog Talk, so I've got my balloon background. I got a fun one. It's from Unclean Hands. Unclean Hands has been around a long time, getting after the soft sits and the auditors. I think he started before me. I'm not sure. Around the same time. He's always been good to Law Talk with Mike. So I'm poaching his video. No, it's sent to me by Lisa in Discord. It looks good. I have not seen it. I only spot checked it. I picked a couple of random spots, and it's absolute lunacy. I don't know what the substance is. I don't know what the court hearing is about, but the participants are absolutely out of their freaking minds and so rude to this judge. It's got a fun title. It's he calls it Explosive Day in Court with the Tasmanian Kitten. That makes me think that he has more videos on this topic. He's had enough videos to develop a nickname for one of the participants, and that is Tasmanian Kitten. I don't know why. That's my guess. That's my guess. Let's get into it and see what all the crazy is about, shall we?
So I'm going to start with Victoria again, because I think we've had more hearings and it's a little bit easier path for me to start with. And then I also noticed that Len had filed some motions which we'll address, and then we'll address the pretrial motions in limine. So, and I'm sorry, I'll just refer to you as Victoria and Leonard just because Miss and Mr. Krivolikov can become confusing sometimes on what I'm saying. So it looks like you filed a motion to dismiss subsequent to any hearings we had, and it appeared in looking at it, and I'm summarizing at least what may not have been specifically addressed at the hearing that we had previously was the lack of a search warrant for the vehicle where the deputies took you out of the vehicle. I just looked at the findings of fact and conclusions of law that Ms. Sinclair prepared from that hearing, which I think she provided to you by email after our last court hearing. Is that right, Victoria?
I got it on 28th.
Okay, and so I noticed, at least in the findings.
Wait, are you kidding me? This guy's actual name is Siberian Tiger? Or is it a woman? I don't know. We'll find out.
Portion, and I just want to direct you to the number once I find it. Okay, number 9 on the findings, which is on page 3. It says Sergeant Agar indicated there was probable cause to arrest the defendant. There was no warrant for the defendant's arrest and no search warrant for the vehicle located in the driveway of the defendant's residence. And then I did not notice, and Ms. Sinclair, you can let me know if I'm missing it. I did not notice that I made a specific conclusion of law that the court is concluding there's exigent circumstances as an exception to the search warrant.
Okay, so they filed a motion saying there was no warrant for his arrest or for the car that they impounded. And this is where the Siberian Tiger doesn't understand the law, and he's going to lose his shit a little bit over this because she's not going to find in his favor, so enjoy.
Requirement. Do you recall if you included?
Okay, obviously that was Unclean's hands talking there. It's his video. Big shout out to him. Linked his channel and the video in the description below. But I'm kind of excited now. We not only have bad law, we've got a Napoleon complex. Let's go.
That, and I might not have said it, so it might not be why it's not in there.
Correct, Your Honor. I don't know. I don't have an independent recollection that you said it, and I don't believe it's in my conclusion.
Okay. So I'm just going to put court is concluding. There is an exception to the search warrant requirement in this case. I can spell.
Excuse me, you're finding the
In this case, due to exigent circumstances.
What was the exigent circumstances?
And that was based upon the testimony from the officers about the safety concerns and everything else that's in the findings of fact. So that would be the exigent circumstances.
Are the parties in that small box bottom right? Because I don't see any movement. I really want to see these people now.
So for you, Ms. Krivolenko or Victoria, for you, I'm including that. I've made it number 9 in the conclusions of law. And then because if we go to trial, if you get convicted, then you have a right to appeal everything.
Thank you, Rusty. That helps. That gives me some orientation here.
Including my pretrial motions. And so it's going to be in there that there was no warrant and this was my conclusion of law. And so the reviewing court will want to make sure they see what I did on my part, but then you have a right, you still have a right to appeal it.
The safety is not one of the issues, is not one of the exigent circumstances. Judge,
Okay,
you
you're
need
not,
to go back.
you're not her lawyer. You're not her lawyer. Okay, you can argue with me, but that's going to be my conclusion of law. So, like I said, if you guys appeal it, which would be, if you get found not guilty, you don't have to worry about it because there's not going to be, there's no more case. So there's nothing really for you to appeal. If you get found guilty, you have a right to appeal.
Oh, great. This is just a new rabbit hole. That's the last thing I need. But now I do want to see the repo.
your finding of facts and finding of law. Officer safety is not an exigent circumstance.
Okay.
Cite me the law. Cite me the case law.
Sir, I'm not arguing with you. You are not her lawyer. So
Okay, I
that's my
understand
findings.
that. No, hold on. I get that. But I do want to know what the law is.
Okay, I just told you. There is an exception to the search warrant requirement where there's exigent circumstances. It wasn't let me finish. It wasn't just the safety of the officers from the testimony. There was concern about your own safety. So you guys can disagree.
I did not ask him to protect me. I did not ask him to protect me.
I get that.
I was safe in my vehicle in my driveway.
Okay, I get that. You guys arguing with me isn't going to change my mind. All right, so you can make
You know what? I had enough. I'm done. I move to recuse you. I'm sorry. We're not going forward.
So we're not friends then?
Off, Dad.
I need a different judge.
Well, you're not going to.
I move to recuse. I mean, these people are out of hand. They're out of hand, but they're a perfect couple. They're both absolutely insane.
I'm done. I've been patient enough. I've been patient enough with all of this. I am done.
Okay, Ms. Krivolenko, I have you set for trial next week, and I'm expecting you to be here, or there's going to be a warrant.
We want to. We're biased judge.
I am not recusing myself. I've already made rulings on your case. That's not a ground to get the court off the case.
Then we're going to ask for replacement.
We're moving for a replacement. We want to hear it.
Like I said.
Well, if the repo video is on unclean hands, I recommend going over there and checking it out. Once again, link in the description. Give them some love. Maybe a subscribe while you're over there.
You can appeal any decisions that this court makes.
There's no appealing. There's no appealing. We're done.
You're going to have a hearing for a replacement. We have moved to recuse you. You have shown extreme bias and prejudice against both of us defendants. You have acted.
I've been very patient with you.
No,
very patient.
we are done with this.
I've been very patient.
She's been very patient with the judge who's showing extreme bias and prejudice. Let me tell you who's going to show some extreme bias and prejudice from the 30 seconds I know of you. Me. I've got nothing but extreme bias and prejudice from what I've seen from you people so far.
It's pretty obvious they've been very patient with this judge, and they just about had it. They want to recuse another judge. I think they've got a couple recused already, but this lady ain't going for it. She's just smiling at him, just having a good time.
I was hoping that there's actually a proper law. There's actually somebody decent enough on the other end, and just enough that I will look at my side and see what's going on. At this point, you're not. You're absolutely biased.
Okay, I understand your position. I've made my ruling on your case. Mr. Krivolenko, I'm going to...
The case law is clear. The federal law is clear. The Constitution is clear. Exigent circumstances do not apply on private property on a driveway. There are no exigent circumstances in that situation. You can't even cite the case
I don't think it's clear.
law. You're making this fabricated ruling that you personally made up, and none of this applies in case law, none of this applies in statute. So you, Judge, we are
Okay. It is clear. It's clear that you lose.
firm on you recusing yourself because clearly the bias you have displayed here, and in fact, when you were even speaking and including me in this case, before I was even a defendant, shows that you have prejudice, extreme prejudice against both defendants in this case. And no, we are not going to move forward until we have a hearing for your replacement.
Okay, well, there's not going to be a hearing on that.
Well, there's not going to be a trial because, first of all, let's bring up the next
You
issue.
need to show up for trial next week or a warrant will go
We
out
can't have
for
a trial
arrest.
because we're not ready. Because the
He can call himself the Siberian or what is it again? The Tasmanian kitten. But I'm going to go with Boris and Natasha.
state has not produced all of the discovery requested.
In other words, they're not agreeing with Mr. and Mrs. Siberian Tiger, so they're just not going to go to court.
We have the right to
We're
call
waiting
witnesses.
months and months for the discovery. Still nothing.
Where is the third witness? Where is all of the police reports that have not been turned over yet? How can we be ready and have a fair trial when the state has failed in its obligation? That's a ground for dismissal right there, immediate ground for dismissal. I can speak on my case. I can speak on both cases because now, first of all, you haven't joined the cases yet. So who's
Yes,
going
I
to trial?
did.
Me?
I joined him last hearing when neither one of you objected, so they were
Where is the
joined.
order signed? I haven't gotten a copy of the order signed by you.
It's-
Email me the order.
I apologize, I'll get that over this afternoon, Your Honor.
Oh, this afternoon? How many weeks did you have to prepare?
Okay,
Counselor?
you know what? This isn't gonna work, okay? So
Of course it's
just
not going to work.
stop.
Not the way you want it.
We requested some of the evidence since May. Since
All
May,
right.
I've been waiting for some of the discovery. Nothing still.
You guys,
We-
just stop. We can
No, we're
take
not
one
gonna stop.
issue
You
at a
need to
time.
stop.
We could take one issue at a time and I can address them if you let me do that. But if you sit there and just yell and scream at me, we're not gonna get
Oh, we're
anything
not yelling.
accomplished.
What the heck is wrong with these judges in Oregon not using contempt? He could have been in contempt 2 or 3 times by now by just the way he's running his mouth in court. But no, I don't think so. Not yet, anyway.
So, backing up, and I had a motion filed by Leonard, a motion to dismiss. I don't have anything in there about lack of discovery. I do not know what you're talking about. I cannot operate in a vacuum on what discovery you're saying you've been denied.
I
So you
brought that
wanna-
up on the last hearing.
Okay,
Judge.
but-
I verbally brought that up. It was made clear. Go look at your own record. I brought up that issue about
This is the
discovery.
third time we're bringing up the same issue
Now-
of discovery. Third time.
We have made multiple attempts to meet with the state, to meet specifically with Prosecutor Sinclair. She would refuse, blankly refuse to come out and have a conversation with us. So nothing, this is on us. We are entitled to a fair trial, and we are not receiving a fair trial. You have a motion to dismiss for lack of evidence. You have a motion to suppress evidence by Victoria. You have a motion that is still pending, 3 motions that haven't been heard yet.
Because
Now-
you're not giving me a chance to address those. I have heard
Okay,
Victoria.
are you addressed the one that we got on Friday? Okay, hold on. I'm gonna be mostly calm. You addressed the one that's on Friday, but the one I filed way back have not been addressed. Do you see the fairness in this?
I did address your motion. We had a hearing.
Okay, it sounds like it's sped up, except when the judge talks, she sounds normal. I don't know. Are these people like that jacked up and then like on 1.5 times speed?
Which one?
We had a 2-hour hearing on it with multiple witnesses on a
Yes.
motion that historically doesn't require testimony.
There are 3 pending motions still. Defendant's motion to dismiss with prejudice for insufficient evidence. Has
Right.
that been heard? No.
Yes.
There's
I
another
ruled
motion.
on it. We just
Defendant's
entered
motion
findings
to
of
question.
facts. That's on Victoria's. I ruled on it. We did a 2-hour hearing. You argued. I made an oral ruling. That has been addressed. You filed
No,
a
it hasn't.
And you lost, dummy.
supplemental motion to dismiss. I'm just referring to Victoria. That was the grounds that you filed it. I don't need to hear new testimony on
Seriously, I want you to put your heart in it, like you care. More passion and more cowbell.
because it was addressed at the hearing, the previous hearing, which had to do with the not having a search warrant for the vehicle. So
Correct?
I have clarified, although you disagree with the court's ruling that there's exigent circumstances for removal
What's
from
the
the
exigent
vehicle.
circumstance, Judge?
I've
What
already
you have
told
alleged
you,
is
I
not an
read it,
exigent
I added it
circumstance.
in.
Go read the law.
You
Go
have-
read the law.
Okay.
There
I
are
read it.
only 4.
I'm muting you guys because I cannot talk and have you yell at me at the same time.
We need an undercover cop disguised as a prostitute so we can arrest any citizens looking for cheap thrills.
So I'm making a record, and I will allow you to unmute yourself after I've been allowed to make that record.
Reason 5,463,000 why I'm not a judge. 1, one suggestion that I need to read the law from a goofball like this, and they're in contempt. Just one. No warnings. Just, that's it. That's it. We're not doing it.
So on the other motion specifically that Victoria filed, it's a motion to dismiss. And in that motion, it looks like it may be reiterating some of the motions in your original motion, but in this motion specifically, I know that you reiterated the fact that there was no search warrant and that the evidence should be suppressed on those grounds because they went into the vehicle with no search warrant. That's what I've ruled on today because that was addressed at the hearing. I just did not specifically make a finding as relates to exigent circumstances. So the reason we have reviewing courts or appellate courts is because if a court determines I made a mistake, then they will review it. So that's how that works. Once I make a ruling, if you don't like my ruling, that is not grounds to have me removed from the case. Now, if you guys want to go back to discovery, you have in general told me that the state has violated discovery. I need to know specifically what you're talking about that you have not received. So one of you, one at a time, can tell me each in your case what you're saying the state has violated by not providing to you. So I'm going to start with Victoria and then I'll do Leonard. So you guys can go ahead and unmute yourself because I muted you on my end.
There was a third witness.
Okay.
We have no names. We don't have any documents on that witness. We have it on video. We know it exists.
Okay, on video. What else?
All the remaining police reports. We didn't get all of them.
Okay, what police reports? I have no idea how many police reports there are. Can you tell me which ones you did receive and then which ones you think you may not have received?
So these are the ones. These are the ones we received. Okay, just go back. I'm gonna help you. Sorry, I received Edgar Gregory.
So we got Edgar Gregory. We got that one.
Okay, wait a minute. I'm sorry. It's AGAR, right?
Yeah.
Okay. And how long is that report that you received? Just to make sure, because in case there's more than one report.
How many pages?
Yeah. Does it say how many pages it is?
Well, it's one. Basically, supplemental. All comes together. So one.
Okay, clearly this is sped up, but it's probably a good choice. And another shout out to Unclean Hands. Clearly he edited the hell out of this thing because it's clipping along pretty well.
Just his report. There might be more than one. 2 pages?
Three pages.
Three pages? So these are ones you've received, right?
With the cover sheet, 3 pages.
And also a report by Officer's Declaration of Probable Cause. Report by Christopher Fisk.
Wait. Can you stop a second? Who's the second report you said you received?
Christopher Fisk.
Fisk. Okay, and how long is that one?
1, 2, 3, yeah.
6 pages.
6 pages. Okay, then I think you mentioned, did you mention another report that you've received?
No, that's it.
So you've received a report from Agar and a report from Fisk?
Yeah.
That's it.
And what is it you believe that you're missing?
Well, we're missing. There were all these other deputies present.
There were a lot of deputies present.
Okay, not everybody writes a report, so do you have any reason to believe that someone else wrote a report?
We absolutely.
But there has to be in this mess. I mean, I don't think 2 people wrote the whole thing.
How can I understand?
But how can I know if I don't have any?
Have you received any other evidence? Was there a body cam?
We receive a lot of body cams, yes, but we're still missing. Well, we found out that I guess my arresting officer didn't have a body cam. Well, no. Let's put it this way: he didn't have the body cam, but he was trained by somebody. That's how I know.
Which officer did not have a body cam?
Well,
Was it Fisk or Agar? Or
No.
Shin.
Shin. My arresting officer, Officer Shin, didn't have a body cam.
Do you know how to spell his name? I'm sorry, you can't.
SHIN.
SHIN. Okay. And then you have received body cams. Are those from Agar and Fisk?
Yeah.
Okay.
But we have
like
deputies.
15 names, extra names. You're telling me nobody else wrote a report?
I don't control it, so I'm going to switch over. I just want to get from your side what it is that you think you're missing. So you think you're missing reports from other officers that were present. You're missing information on a third witness that was present. You don't know his name.
He's on the cameras, but he's not listed anywhere.
Okay. So am I missing, other than additional reports, other than Agar, Fisk, and body cams you received, is there anything else you think you're missing?
Well, does the prosecutor have the list of the deputies that were present? I mean, it's a list.
I am going to switch over to her in just a second, okay? But I want to make sure that she's able to address what you guys think you're missing. So, other witnesses and officers, you believe you don't have any of the evidence from those individuals, if I'm summarizing that correctly. Is that right? Correct. Okay. All right. Now I'm going to switch over to Ms. Sinclair because I don't know what the law enforcement did or didn't do. So I have to switch to her to find out.
Thank you, Your Honor. So in our case, we'll first address Ms. Krivolenkov's case.
Who I'm sorry, is that?
Victoria,
Okay,
sorry.
Thank you.
Discovery packet was prepared for Pro Se to pick up on February 6, 2024. It looks like she picked it up in the lobby on March 14, 2024. We sent additional body cam footage saved to defendant photo, or to Pro Se at evidence.com on March 14th. Then if the court recalls, and that would have included, Your Honor, the main report that was drafted by Deputy Fisk and should have included the supplementals by Agar, Morgan, Clemenhagen, Nielsen, and Freudenberg.
We don't have any of those.
Is it in print?
Okay, please let me finish, and then I will continue. So there is a factual dispute here because they should have gone out. Now, when we were in court, if the court recalls, on July 16th, Victoria raised the issue of tow truck video evidence, and we also have the questions about Deputy Shin, if Your Honor recalls, because he had the pre-book sheet. He was able to confirm via email while the court hearing was going on that he was ordered to transport or do the pre-book, but it was actually listed in the probable cause statement that the probable cause statement was drafted by Sergeant Agar, which is consistent with his supplemental report. Shin also confirmed that he had not been fitted at that time with a body-worn camera, so that's why there was no body-worn camera from Deputy Shin. It was also raised at that point that we had outstanding potential tow truck information, so that was provided to Victoria on July 16th by Rebecca Manrique at our office. We also, as a precaution, resent all CCSO reports with supplemental 6 to Pro Se. So we resent all of the reports. So we're having a bit of a factual dispute, Your Honor. The statement submitted that we have supplied all supplementals, Agar, Morgan, Clemenhagen, Freudenberg, Nielsen, no later than July 16th. They should have gone out back in March. They prepared on February 6th, and I'll confirm that with Ms. Manrique. But we aren't withholding that information. Our records indicate that we provided all supplementals. Again, on July 16th, the only new information looks like was supplemental 6, and that would have been, I'll confirm exactly whose report that is. I suspect it's a supplemental to say, here are the tow truck videos. As Your Honor is aware, we are not proceeding on the harassment charge. At this time on our witness list, we have Agar, Clemenhagen, Agar, Fisk, and Freudenberg. Those are the 3 witnesses we're proceeding with on the 2 obstruction charges. We are not aware of any third tow truck. All law enforcement police reports point to there being 2. That 2 were interviewed. A Mr. Hardy and a Mr. Bates. There's no evidence that we have that support there being a third person. I'm not here to dispute or say there was or wasn't. I'm just simply saying it's no longer relevant. We're not proceeding on a harassment charge. We don't have any additional information that there's a third witness. Nothing was reported, both on the 911 call and even in the tow truck video. You hear 2 voices and 2 voices only. So I don't have any information about an unnamed third person. I certainly don't have a name that I am withholding. And it's our position that we provided everything and did it again on July 16th. And the July 16th, we do appreciate Victoria mentioning the tow truck videos. She mentioned it then. She did not say she was missing other police reports other than Deputy Shin's, who then confirmed he did not write one. She just mentioned Deputy Shin and the tow truck. And so as a precaution, we resent everything we had and added the tow truck videos, which we appreciate her mentioning.
Okay, if you're not quite sure what's going on, Mr. Tiger, every time he gets a motion denied, he files a new motion for the same thing and words it different, and it's all a bunch of nonsense. He's gotten everything he's asked for. It sounds like they're going to look to see if there's anything else, but as far as they're concerned, they provided everything that they're going to be producing in trial.
So we could get that over to her, although now the state does not intend to introduce those videos. So we would just be relying on the body-worn cameras by Deputies Agar, Fisk, and Freudenberg along with their reports, which would already have been sent.
Okay, so you rattled off a lot of information for
I did.
me. So I'm going to back you up for a second.
I can,
Yes,
I can wait.
on how do you account for what specifically, so you said there was a packet at the very beginning that she picked up that you prepared of discovery. How do you document what was specifically in that packet that was released to her?
Thank you, Your Honor. I'm reaching out to Ms. Manrique right now.
Okay, we're gonna speed through some of this testimony from the DA there because it's pretty much useless and boring. until we get to some more fireworks. We want more fireworks here.
No, I received a portion of the reports, but all of the deputies that were present, I don't have the reports from all of the deputies present.
Okay.
I can go down the list of deputies that are known to me, and I did not receive those reports. So what I do have is what I can confirm as far as reports. I have Chris Fredenberg, I have Shane Clamenhagen, I have Patrick Morgan, I have Agar Gregory, I have Zach Nielsen, I have Christopher Fisk.
And she said a PC statement and a search warrant. Did you receive those?
I did receive that. Well, I drafted a search warrant, not a search warrant. It was never authored. There's no signature of a judge, so I got a draft. So somebody needs to give me a signed copy of the warrant, which I did not receive by a judge. So what I have is I have a draft. I don't have an authored search warrant. So that's still missing. So go back and find me an authored warrant signed by a judge in the issuance of the warrant. I have a blank draft. Blank. Okay? Does that make sense?
Yeah, no, I understand what you say, because telephonic warrants are allowed, and oftentimes the judge, and I'm only saying this because you did include a report on your motion to dismiss let me look at your motion so I don't mistake, because I don't know what offer it was. What officer it was. You guys know that better than I do, but you included it with your motion to suppress evidence.
Right, not motion to dismiss, so I was a little confused there. I did not submit the motion to dismiss on this case.
I think
I
it's
submitted the motion.
motion to suppress.
That's correct.
And this one, oh, that's approved by Volker. How can you tell the name? Oh, this is Fisk, it looks like, is the report that you included. I think this is all Fisk. It's kind of difficult to tell.
Yes, this did the search warrant.
Okay. And on there, so I'm only saying this, there should be something though when they filed the search warrant. So I guess what you're saying is, or let me ask you this. Is the copy that you received in discovery, does it have a filed stamp with Superior Court on it?
No, it does not.
Okay. So you have not received the file, because what I was going to tell you is that those warrants can be authorized telephonically, and or we do it by email, and then the judge who reviews it has to give the officer, has to tell the officer basically they found probable cause and give them permission to affix their signature to that warrant. So you're saying that you never got a page or anything attached to the warrant that was filed with the court with that information on it. Is that
That's
right?
correct.
It is all blank.
It's blank.
Right, I get you got a copy of what the warrant says, which is what the judge would review, but you don't have either it being signed by the judge, which from the police report you gave me sounds like it was done electronically and he reviewed it by email. So he would have returned an email that said I reviewed it, I'm finding probable cause, you have my permission to affix my signature to that document. That's the page you don't have, although it's indicated in a police report, you don't have that page from the judge saying that I'm approving this warrant. Is that correct?
That is correct. And I've also requested a copy of that email or any email related to the case, which I have not received.
Okay. So I think as far as Leonard, and the body-worn camera, Leonard, you received that information, that footage as well?
I received that footage, but again, we need to go back to the witness, because irrelevant what the state is implying here, whether they're going to pursue with the harassment charge or not, we still have every right to call every witness, material witness, and question them to establish why there was police presence. So I have a right to self-defense. My wife has a right to self-defense. That's an affirmative defense. So unless the state can prove that there was actual cause for the officers to be there, which they have to exercise their duties, correct? What was they investigating? What was the call? Because I did not make the call. My wife did not make the call. We have the right to question those individuals. I want to know who they are, and why was my vehicle taken from me unlawfully?
It was being repossessed because you failed to make payments on it, and they were coming to get it back until you paid it off, or paid off what you owed. That's exactly why they came, to get it, and then you threatened them and you wouldn't let them leave your driveway. You blocked them in your driveway. That's why the police were called.
Okay.
That witness has all that
All right.
information.
So what they have to release to you is
Also, this little nugget: if you assert affirmative defense, now you have the burden of proof to prove your affirmative defense. He got that a little mixed up and thought that it requires some additional burden for the prosecution, which it doesn't.
information that is known to them that they have in their possession. So with the exception, I'm going to verify, but it sounds like that
In other words, wrong on all fronts.
information, at least as far as Leonard is concerned, what the state had in their possession has been released to you. But before I let you go, Leonard, you did mention, and I'll have Ms. Sinclair double check, that you do have some names of other officers that were present that you don't have a report for. So
That's
I
correct.
need it, before we go, don't let me forget to do that. I'm going to circle back to you on that. I'm going to get those names to see if they authored a report. I can tell you not all officers author reports, even if they go to the scene. I can't tell you specifically whether or not that's the case in your case until we double check and make sure that's the case, okay? So I can just say in general, I know that not all officers author reports every time they go out to the scene, because there's usually 1 or 2 or 3 main officers. If they didn't unfortunately write the name of the person, the third person that you're saying was there, that may be something you guys can get by, I assume they provided you other witnesses previously, i.e. the tow truck drivers or the towing company that you can contact, and you have every right to see if there was anybody else present. You are
I can-
correct, at the time of trial, the elements obviously are, I mean, you guys are just trying to get me to circumvent this, I'm not going to be the fact finder, a jury is, but the elements are, is they're going to have to prove, as you've indicated, beyond a reasonable doubt, that they were there performing their official duties and they had a right to be there, and that your actions, yours or your wife's actions, obstructed their ability to do those duties. So I'm not saying one way or another whether they have to present evidence. That's the whole crux of the case. They have to prove their case. So they have to put on that evidence. If that makes sense.
Well, do they have that evidence? Does the state have that evidence?
They have
That's
that.
the reason why, Judge, we have.
They have that evidence. They have enough. So the motion that Victoria filed kind of challenged the sufficiency of the evidence. The standard for me pre-trial is going to be a little bit different than the standard when you go to trial. The standard pre-trial is taking the evidence in the light most favorable to the non-moving party, which happens to be the state because they weren't moving to dismiss. Then is there enough evidence? And the court said yes to that threshold decision. That's not the same as was there enough evidence beyond a reasonable doubt. We only get to that when they present the evidence at trial. And then it's a question for either the jury to decide or some halftime motion whether or not there's enough for a jury to decide that. But they have a right to basically get through the door to present it at trial. It doesn't mean that they've proven by any means at this point in time beyond a reasonable doubt all the information that you are contesting, right? Does that make sense?
Okay, so hold on. So just to clarify, you said on the ruling that there are circumstances, exigent circumstances, correct?
Right. I'm ruling on that as a legal question. That's not the jury's not going to decide whether or not there are exigent circumstances. They're basically, we'll have to look at the jury instruction for the specific
Jesus.
elements. But if you look at the charge itself, they have to prove that they had a lawful right to be where they were and they were performing their official duties.
These people, they're just it's typical like soft sits in all of them. Like they're so obnoxious, but then they don't know the most basic things. So then they have to use the judge as their attorney. And she's like nice to him. I wouldn't be nice to him. After they ask me to go read the law, I would say, apparently you know better than I do. But here's my ruling. Suffer.
And then that somehow your actions or Lennon's actions hindered their ability to do, hindered or delay, I think is language in the statute, their ability to carry out their duties. That's what they have to prove beyond a reasonable doubt.
Okay, so I have to go to court, just to clarify, and I have to present my case, but I still haven't you haven't given me exactly the rule and what are those circumstances. So I can somehow,
That's not her job, dummy. You're representing yourself. You're supposed to get familiar with the law.
Okay, first off, you don't have an obligation, this is going to be in the jury instructions. As a defendant, you have no obligation to prove your innocence. The burden is on the state to prove your guilt beyond a reasonable doubt. Now, you can choose to present evidence. That's totally up to you. A lot of people do because it helps explain your side of the story, but it's up to you. You don't have to. You don't have to testify. You don't have to put any witnesses on. If you were a lawyer, I've heard lawyers come up here all the time and say, I could just sit here and do absolutely nothing, and as my client sits there, they're innocent, and unless the state proves them guilty beyond a reasonable doubt. So yes, you don't have to prove anything. You are entitled to know what witnesses are going to say. And that's the reason they give you reports and they give you contact information so you can contact the witnesses. She's indicated she's only calling 3 witnesses. You guys can call your own witnesses. You don't have to be stuck with, you don't have to be stuck with who she calls. If you choose, you can call witnesses to testify on your behalf.
But we can't.
Because if we want to call,
We want to call him, but we can't.
Why can't you?
Because the police did not do their investigation.
Well, I can't help you with that. If Miss
Oh my God. I seriously wouldn't do this. I would say get an attorney or learn the law. Here's my ruling. Next issue.
Sinclair doesn't know who that individual is, or the police didn't gather that name, then that's just non-evidence. I mean, you can point out, did you get the name of the person that was standing there? And if they say no, that, you know,
Okay.
that's evidence that they didn't do what they should have done. That it doesn't
Judge?
necessarily, that's,
I'm citing you a case, I'm citing you a statute, RCW 9.94A.
Now that I've asked you like basics of law that I clearly don't understand, now I'm going to cram a statute down your throat, which I also don't understand. Oh, this should be fun.
411, evidentiary sufficiency. 1, decision not to prosecute. This is the standard set by legislator for a prosecutor to initiate or decline to prosecute. So, in section I, police investigation. A prosecuting attorney is dependent upon law enforcement agencies to conduct the necessary factual investigation, which must precede the decision to prosecute. The prosecuting attorney shall ensure that a thorough factual investigation has been conducted before a decision to prosecute is made. In ordinary circumstances, the investigation should include the following. A, the interviewing of all material witnesses, together with the obtaining of written statements whenever possible, the completion of necessary laboratory tests, etc. That doesn't quite apply here. So, the prosecution has to work together with the enforcement agency or police officers to conduct an investigation. That's not my responsibility. That's the responsibility of the state and responsibility of the officers. They're the ones who are investigating.
Yeah, you know, now we're talking about responsibilities. What your responsibility is to know the law. What the judge's responsibility is to explain it to you. Now shut up.
And interviewing witnesses. Now, if they fail so to do, I'm going to make a blunt statement here. It appears so that the state is obstructing justice, that the state is interfering with witnesses, that the state
I am going to make a blunt statement here.
is protecting those witnesses, knowing that they are criminals, and knowing that it probably most likely would also implicate officers in criminal conduct. So no, we are not going to proceed to this trial until my rights are upheld and my due process is upheld. And so you can go ahead and set this over. You can smile all you want, Judge.
Wait. He's not doing anything until his rights are felt? Is that what the hell he's saying? Am I not hearing that right? I don't know.
You can smile all you want, but you will not violate my due process. And you know that. So unless you're going to recuse yourself, I will immediately file a complaint against you, and I will file a motion to remove you, because this is not going to work out with me. Previously, the state has also been very, very, very bad, submitting evidence into record that has nothing to do with this case. 2 images submitted in the filings of Victoria that have nothing to do with this case, right? Now that.
okay, let me respond. Starting on top. Number 1, I can't control, there's called separation of powers. I'm the judiciary. I don't control the role of the prosecutor or the prosecutor charging, or what they may or may.
I don't even like the phrase, let me respond. I don't like it.
Not charged. So what you were citing as the statute you were reading are guidelines for the prosecutors on charging. When you talk about witnesses, you talk about material witnesses. I do not know at this point in time whether or not this witness was material or not, so I cannot address that. It is a question you can ask of the officers, whether or not they interviewed all witnesses at the scene. You can't jump to a conclusion, nor can you argue to the jury without evidence that these witnesses were hiding something, that they were material, that they're criminals or whatever, without even knowing who the witness is. So that would be improper argument. But you can point out if the law enforcement officer didn't collect certain evidence that I guess they could have collected, that is a reason for the jury to take into consideration the credibility or the validity of the investigation in your particular case. All this stuff about, I don't know the other stuff. I've already ruled on, I'm not going to recuse myself. At this point in time, I think if you want to file an appeal for my refusal to remove myself, you would need to do that with the Superior Court. I can't really advise you on that, but you have a right to look up what your appellate rights are. As far as I know right now, I have you guys set for trial. I don't know if you're asking me to continue it because you feel you need more time. That is something that would be up to you, but I'm honoring your right to have a trial within speedy trial, and right now that trial is set for the 8th of November, which is a week from Friday. So I am intending on going to trial on that date unless you're asking for a continuance today to allow you more time to appeal that decision, or you get some ruling from Superior Court that says I absolutely have to stop and recuse myself. But unless I'm ordered to stop, I've already ruled on it. So the only way you go above me is to appeal it, and you're probably not going to get through the doors of the appellate court before next Friday. The appellate court in this case is Superior Court. They review district court appeals. So you would be doing some sort of injunction before an appeal based on a guilty finding or guilty verdict. All right, I don't know if I addressed everything, but I think I addressed most of what you're saying. So the main thing for me is I have a set for going to trial on Friday, and I'm trying to work through the issues I know that are in front of me today, but we're having difficulty getting there because we're getting on sidetrack. So are you guys, all I hear you saying is, well, we're not accepting you as a judge and we're not going to go to trial on Friday. So if you want to ask for a continuance and get some time to appeal the decisions I've already made, that's up to you. But other than that, I have you come into court next Friday morning. And you could, sorry, you have to unmute yourself. I muted you again on this end.
That is not the only issue we're raising about your bias, about the prejudice, but you haven't even stated, you have mistakenly, improperly, without any support or backing on any grounds in any case law, what the exigent circumstances is. Officer safety is not an exigent circumstances. This is not a hot pursuit. This is not a traffic stop. There was no danger to the officer or the
Any objection? All objections.
defendant. We never requested their assistance. They were there unlawfully. They were there in violation of constitutional rights. There was no issue of evidence destruction, no vehicle emergency, mobility, or any.
Okay, Jackass, do you want a continuance to file appeals, which we'll lose, or do you want to proceed to trial next week? That's what the only question on the table. That's it. Nothing else.
Burning fire. So what you raised as an officer safety is not one of the elements or one of the exceptions to the exigent circumstances, Judge. You should know better than that. Second of all, yes, we want.
She didn't raise shit. She's the judge. The prosecutor is prosecuting the case.
Time, and we have the right to have time. So we are asking for continuance firmly so we can appeal all of your decisions, including your recusal. So yes, whatever the deadline is, let's set it over. Because what's happening here is this is not a fair trial. This is not at all fair trial. So we need. Whatever the deadline is, let's set it over. All objections, and let's push back all deadlines. Okay. To set this over. We need a continuance, but we are not waiving our right. So push it to the deadline so we can have time to file this appeal.
Yes. I want a continuance, but we're not waiving speedy trial. The judge deserves it by being too nice. I'm sorry. She knows law very well. She's very smart, but she does not know how to handle an animal like this.
I'm a constitutional law scholar. I'm a constitutional law scholar.
Okay, that's fine. I will continue it. I do have some trial dates in December. I also have some trial dates in January. How much time are you requesting?
January.
Okay. I think what would be best is to just do January 9th or January 10th. That's a Thursday or a Friday.
January 10th.
Does that work as far as you know, Ms. Sinclair?
Yes, Your Honor.
Okay, so January 10th, and then I imagine we may or may not have motions before then. We'll have to see if you do get it reviewed and what the decision is. All right. That should conclude it for today.
Well, thank you, Unclean Hands. That was fun. Go over there, give him some love. He does editing and everything. That is a new rabbit hole for me. I'm learning from my chat that this repo is out there somewhere. We suspect on Unclean Hands channel, or maybe somewhere else. I don't know. The repo video has got to be good. With those two knuckleheads and like cops coming, I can just see them just. My vision is they're just chirping away, and there's like some big beefy cop just going, yeah, get over here, and they're just pulling it away. They're crying like big blubbering babies. There's glass breaking, babies crying. You know the whole thing. What was it? It's gonna be a lot. I gotta see it now. I gotta see it. If somebody knows where it is, send me the link. Send me the link. Thank you all for coming out. I appreciate it. I'll see y'all soon.